Hi, I'm Luke Nichols. I'm an attorney here with the law firm of Nichols Green in Northern Virginia, and I'm going to talk to you today about DUI defenses and the common ways we defend people accused of DUI. Now, essentially, there are three common ways we defend people of DUIs. There's lots and lots of different defenses, so I'm taking a very complex area of law and synthesizing it down to its basic parts and principles. But there's three common ways we defeat DUI cases. The first is we attack the constitutionality of the traffic stop or the initial police encounter. The second is we attack the constitutionality of the arrest. And the final way is we attack the totality of the evidence. We say that all the evidence altogether can't prove beyond a reasonable doubt that the person was guilty of drunk driving. Now, let's talk about the initial stop. When you say that the traffic stop or the initial police encounter is not constitutional, what you're saying is it violated a person's Fourth Amendment right. This is your Fourth Amendment right against unreasonable searches and seizures. And the Supreme Court of the United States and the Supreme Court of Virginia have both agreed that in order for an initial traffic stop to be constitutionally valid under the Fourth Amendment, the officer must have reasonable, articulable suspicion of criminal activity. The officer needs to be able to articulate his suspicions, and those suspicions must be reasonable. It's a two-pronged test. It has to be articulable and it has to be reasonable. What I mean by articulable is the officer has to be able to explain himself. Often DUI trials are months after the DUI arrest. This officer has had hundreds of traffic stops since your case, and he gets up in front of the court and maybe his notes aren't very good. Maybe he says, I pulled him over for weaving. Well, weaving can be a good reason to pull somebody over and investigate them for DUI. However, the officer has to be able to articulate it. He has to be able to describe the weaving in specific objective details. So if an officer just takes a stand and says, oh, they were weaving, that's probably not good enough. If the officer gets up and says, I followed them for 1 mile, and in that 1 mile, their left tires crossed over the yellow line 3 occasions, and then their right tires crossed over the lane divider on 2 occasions. That's a very specific and a well-articulated description of weaving. So the officer has to be able to articulate what he saw, and once he does that, it has to be reasonable. So for instance, an officer can be very articulate in describing something, but maybe it's not reasonable. Let's go back to the swerving example. Let's say the officer gets up and testifies in court, I followed the defendant for 1.5 miles, and their car weaved towards the left lane marking on 4 occasions, and then weaved towards the right lane marking on 3 occasions. So basically what you have is their testimony that a person was weaving within their lane back and forth about 3 or 4 times over the course of about 1.5 miles. Well, that's a very articulate description of what happened, but is it reasonable to suspect that person of being drunk? If a person isn't driving a perfectly straight line, does that really give you a reasonable suspicion that they're drunk? So that becomes the question. So the officer has to articulate what he saw and articulate it well, and what he or she articulates has to be reasonably associated with some sort of criminal activity. In some cases, officers don't have traffic stops. The DUI starts with a car accident, or it involves them walking up and approaching somebody in a parking lot. The same rules apply, but then it becomes more unclear when the stop actually occurred. When did the police encounter go from just 2 people talking to a police officer seizing somebody and controlling their movements? And that becomes debatable. So if a police officer walks up to you in the parking lot and says, hey, what's going on? Hey, have you had anything to drink? That may not be a seizure under the Fourth Amendment. He may not need to reasonably articulate why he came up and talked to you, because he wasn't stopping you from doing anything. He wasn't using his police authority to control you. He was just coming up and talking as two people. But at other times, that's not the case. If an officer walks up to you in the parking lot and says, "Hey, can I see your license and registration?" That's not just a conversation, that's a seizure. He has now seized you. You have to show him your license and registration. You can't leave. So the officer needs to be able to reasonably articulate why he did that and what evidence he had. So this is a very complex area of law. The constitutionality of police encounters is something that has been debated and argued and goes back and forth, and there's just hundreds and hundreds of cases out there talking about the many, many different ways police officers can encounter somebody and seize them under the Fourth Amendment, and when it's legal and when it's not legal. But the end result is that if an officer, his initial encounter with you, either through a traffic stop or other encounters, if that encounter is not constitutionally valid, all subsequent evidence is excluded from trial. And in most cases, that results in a complete acquittal. The case is thrown out. So if that officer did not stop you in a constitutionally valid manner, the whole case is going away. It's an automatic victory for the vast majority of situations. The second way we attack DUIs is we attack the probable cause. The probable cause for the arrest. We argue that the arrest was not constitutionally valid. The officer lacked what we call probable cause. Now, you need reasonable articulable suspicion to stop somebody. You need probable cause to arrest them, and you must prove beyond a reasonable doubt that they're guilty to convict them. So there's these three separate standards, three different levels of evidence that they require. So you can have enough evidence to arrest somebody, you can have probable cause to arrest them, but not have proof beyond a reasonable doubt. So the officer doesn't need to prove that you're drunk driving to arrest you. He just needs to have sufficient evidence to justify the very onerous and restrictive consequences of being arrested. So the backbone of most probable cause analyses is the preliminary breath test and the field sobriety tests. The preliminary breath test is the breath test on the side of the road. It cannot be used to prove that you were drunk driving, but it can be used to justify the officer arresting you for drunk driving. Then there's the field sobriety tests. Of course, those are a loosey-goosey test. They're not a pass-fail test. The officer articulates what he had you do, he articulates what he saw you do, and then the judge makes up his or her own mind of whether that's enough evidence to justify arresting somebody. So a very loosey-goosey standard. You have 12 judges, you'll probably get 12 different opinions about how much probable cause is required, or how much evidence is necessary to have probable cause to arrest somebody for DUI. But just like the constitutionality of a traffic stop, if an arrest is not constitutionally valid, all evidence that comes afterwards is excluded, and usually the case is thrown out. Now, just to put a finer point on that, that includes subsequent evidence unrelated to the DUI case. So for instance, if you're arrested for DUI and refusal, and the arrest was not constitutionally valid, well, you only refused because you were under arrest and at the police station. If you were at the police station under force of a constitutionally invalid arrest, that gets thrown out too. So if you have a constitutionally invalid arrest for DUI, the refusal goes out as well. So it's a real coup d'etat. It's a great way to win a DUI case, and it's one of the most common ways we win a DUI case. The final way we attack the legitimacy of a DUI is we say that there isn't evidence beyond a reasonable doubt, that all the evidence in total, the driving behavior, the field sobriety test, the officer's observations on the side of the road and at the police station, and the breath or blood test, all in totality doesn't rise to a level beyond a reasonable doubt. Now remember, beyond a reasonable doubt is higher than probable cause, it's higher than reasonable articulable suspicion. This is the most stringent level of evidence that the prosecution must put forward. There's those types of cases where the government hasn't proven that you're over the legal limit, and then there's the cases where they have. Well, in the cases where they have, you can still attack the evidence. You can say, for instance, that even though I was over the legal limit at the station, I wasn't over the legal limit when I was driving. So for instance, if you drink a whole bunch of alcohol, immediately hop behind the wheel, you're not drunk yet. It takes a few minutes for the alcohol to get from your belly into your blood and affect your brain. So even though you have alcohol in your body, you're not drunk yet. Your blood alcohol content isn't over the legal limit yet. Well, you get pulled over, stopped, arrested, and an hour and a half later you take a blood or breath test. Well, then the alcohol's in your blood and you're over the legal limit. So that's what we call the rising BAC defense. So that's one way you can show, even though I was over the legal limit at the station, I'm not guilty of DUI. Or if you drink alcohol after an accident. So for instance, a person gets in a car accident, they're all shook up and they go home and take a couple shots, and the police knock on their door and they arrest them for DUI. They take their blood, but they can't prove what their alcohol content was at the time of driving. They can only prove what it was at the station. And because they drank alcohol after they were driving, they can't prove that their blood alcohol content was over the legal limit at the time of the accident. So that's another example of a common way we attack these things. Also, you can attack the accuracy of the machine, the accuracy of the testing procedures. Each one of the breath machines that are used at the police station in Virginia are hooked up to the internet, and all the data from their tests and their maintenance logs and things like that are downloaded onto a server in Richmond. And as part of our DUI defenses, we go and get that information from Richmond. We get a little 20-30 page packet from the Department of Forensic Science which shows the data for our test results of our clients, and the test results prior to that, and test results after that, and maintenance logs, and the licensing reports, and all of those sorts of things. And we can look for errors and problems with the machine. Well, at any rate, those are basically the three main ways that we attack DUIs in the state of Virginia. We attack the legitimacy of the stop, we attack the legitimacy of the arrest, and we attack the evidence in totality. However, there's lots of other things that we can do as well. Sometimes they can't prove who was driving the car. Sometimes they can't prove they were actually operating a vehicle. So there's were they actually operating their vehicle, or were they just parked? There's those types of issues. Other times there's all sorts of other constitutional issues like Miranda rights, whether or not you were properly Mirandized, whether there's a post custody interrogation that comes into play. There's DUI checkpoints and whether they're constitutionally valid, but that falls under whether the stop was constitutionally valid. There's a lot of different issues. So there's no substitute for talking to a competent DUI attorney. So if you have a DUI case here in Northern Virginia, you would like to know about the defenses you have in your case, call us anytime for a free consultation. We can do it over the phone, we can do it in person. After talking for a little bit, very quickly, we're going to be able to tell you what defenses you have, what the likely outcome of your case is, what we can do for you, and when you leave our office, you're going to know very clearly what to expect from us and what to expect from the courts. At any rate, thanks for watching, and once again, please call anytime if you would like a free consultation with a DUI attorney here in Northern Virginia. Thanks for watching.